All right. Well, off we go. So we're here today to talk about statute of limitations, statute of repose, and latent defects, along with some other related topics. So sort of the first thing that I'd like to get into is some context about why we are here. Why do we care, besides the fact that we're all in this industry together? Why we care is because the bulk of cases are resolved by the courts. Thankfully, in my view, more and more of them are heading into arbitration, but we've got some major problems with the courts, and it's part of why these things have such a long life expectancy, right? We've all heard, and we're going to get into, statute of repose, 10 years. Everybody's heard 10 years, and we'll get into the complexities of that. But when you think about that, in the life expectancy of a business and a particular project, if a contractor gets sued in year 4 after a project, that lawsuit may not be done for many years after that. And part of the reason, practically speaking, is this pie chart that you see here, right? In the 17th Circuit, your circuit as an example, as of 2020, or for the year 2020, there were a total of 22,539 case filings. Now, the pie chart I'm showing you is across the entire state, all right, percentage-wise. But in the 17th Circuit, of that 22,000 figure, about 7,500 were in so-called contract disputes, 3,800 in real property, and 533 in business. The rest fell between the other areas. The point that I'm getting at here is there's no standard.
Want to just have yours be allowed?
What was that?
Mine's like behind.
Sorry, Joe, I couldn't hear your question.
Jody, do you have a question?
No.
Okay. There's no standard by which court filing lawyers indicate whether a construction dispute is business, real estate, or contracts, which is why I've listed all three. So construction disputes probably fall amongst all three of those. But the bigger point here is that there is a massive number of cases that don't fall into those categories. The reality is that judges don't see a lot of construction cases, and judges are the ones that dispose of cases, judges and juries. And so in the absence of judicial experience, it just takes longer to get things through the system. That would be like you trying to explain to a doctor who has no knowledge of suretyship or construction what your business is. It's a little bit of a challenge. It's going to take some time. And of all cases, only 72% never actually make it to a judge or jury, meaning they're settled. The reason for that is it takes so dang long because the courts are just not well adept at processing these kinds of cases. And to give you kind of another figure, right, these were the annual filings and dispositions. So, meaning new cases filed and how they were, and cases disposed of, whether via trial, settlement, or some other thing. It starts to look really good, right? So you go, oh, all the cases filed or disposed of, that looks pretty nice. We're not having a drag. Well, the Florida Supreme Court's Chief Justice came out earlier this year and said that the court system now has 1 million cases backlogged because of court shutdowns from COVID-19. And they said, yeah, there's not really much we can do about that unless we get more funding from the legislature. So good luck with that. So that's going to be a struggle for some time. The Florida Rule of Judicial Administration requires that jury trials cases be completed within 18 months of the date a lawsuit is filed, and non-jury trials, so judge-decided cases, be decided within 12 months. That hasn't happened in the almost 20 years I've been practicing law. So these things, just from a practical perspective, they sort of extend the life of these cases and force parties to settle oftentimes just because of the cost and the delay, even if they have good grounds for settlement. So what are we going to talk about today? We're going to talk about warranty versus 558 versus a legal proceeding. These are important terms. Understanding the differences between those sort of on a high level basis will help us better understand statute of limitations and statute of repose and the things that trigger those issues. Implications of statute of limitation rules, right? We've got to cover when the statutes start to run, how you make the statute of limitations deadline or how you meet it and what those deadlines are. We're also going to cover whether you can shorten deadlines and how deadlines are lengthened. We know one of those ways it gets lengthened is via statute of repose, but another one that's rarely talked about that does regularly come into play is tolling. So at a high level, these are the topics we're going to talk about. So let's start at the top. Warranty claims versus 558 versus a legal proceeding. So what's a warranty? It's a promise, right? It's a contractual promise generally. We're all familiar with the typical sort of 1 year, sometimes it's longer, but there are also implied warranties unless they're disclaimed, so implied by law. And then you've got statutory warranties like for condominiums under 718-203, you've got roof, structural, mechanical, plumbing, etc. And the contractor's liable during the warranty period. As I'm sure you all know well, that the performance bond can be on the hook for warranty periods as well. So that's a warranty. It's a promise generally to repair or replace the thing that's broken or something more specific, depending on whether there's a detailed warranty clause. A common misnomer, right, is that when the warranty period expires, the contractor is off the hook. Well, they're not, unfortunately. They're on the hook for up to the statute of repose. Again, we're going to talk about that in a minute. So I distinguish a warranty claim from an actual legal proceeding, whether it's arbitration or litigation. It's arbitration and litigation to which the statute of limitations and statute of repose are applicable, whereas a warranty is sort of a direct promise between the two parties. A claim initiated via legal proceeding is you breached the contract, something other than the warranty, for example, or you failed to build the thing per the plans and specifications, or you failed to build per industry standards if there's sort of a void in what the means and methods of construction are. If they're not specified in the contract, industry standard will supplement. A 558 notice, right? Depending on which body of law you're in, it's a claim or it's not a claim. Those waters got muddied about 4 years ago in an insurance case. But the point is 558 is a dispute resolution process that doesn't really work. Most people hate 558, whether they're on the suing side or the defending side. And every year, there are significant legislative efforts to change it. I am personally involved in those efforts, both on the residential side and the commercial side of the lobby through Florida Home Builders and Associated Builders and Contractors. It's just a terrible statute. But the concept is to give parties, contractors, design professionals notice and an opportunity to inspect and propose to resolve the matter before a legal proceeding is initiated. So that's sort of the high level on those. Any questions about those concepts so far?
From my experience, I've typically seen the 558 notices go out to every single party that's associated with the contract, regardless of whether whatever alleged issue there may be is related or not.
And that's why it's so frustrating, because we've got a client right now who it's a storefront glass contractor, and on this high-rise project, all the contractor did was install essentially glass railings, right? And there's a roof leak, and our client got a 558 notice, and then worse, is named as a defendant in the lawsuit. It is a common issue, and it's one of the things that we've tried to address through 558, and every year just haven't been able to get it done not because the plaintiff's bar, if you will, the plaintiff's lawyers lobby is incredibly strong. It's because of infighting between the residential lobby, the commercial lobby, and the insurance lobby. They just can't agree. And so there's that old saying, two things you don't want to see being made are laws and sausages. Well, I like sausages. I've made them and I've been involved in the bill making process, but it's ugly. It's not clean. And you're right. It's a big problem and it happens all the time that way. Any other questions there? All right, moving on. So statute of limitations, general rules, right? So now we're talking about, we are in the legal proceeding, the middle section. All right, so some terminology we got to know. What is a statute of limitations? It's a deadline to commence a legal proceeding after accrual. What the heck does that mean? It means, accrual means when the thing starts, right? Think of it as a stopwatch. So accrual is when you hit start on the stopwatch. A deadline is a deadline. You got to do it by this date. And commence is also a term of art. If you think you've taken action, but it's not a commencement, then you're in trouble. You've not complied with the statute of limitation and your claim is gone, which is a good thing if you're defending. So what is commencing? It's a formal filing event. It's either going to be a lawsuit or a petition for arbitration filed with, for example, AAA. A lot of lawyers on the plaintiff's side, just to dot the I's and cross the T's, will file a lawsuit and simultaneously a petition for arbitration if it's an arbitration matter, just to make sure there are no arguments that it wasn't timely commenced. But there are some exceptions, right? So you commence a legal proceeding in a court, for example, you file a complaint with the clerk of court. But there are some exceptions to that, right? So 558, notice I mentioned this is one of the areas where things get muddy. 558 notice, serving it, mailing it, is deemed commencing an action for purposes of statute of limitations. Why? Because the courts have basically, the case was essentially this. A 558 notice was sent within the period of the statute of limitations, right? And then you have, let's say it's a single building structure, not a multifamily, not a condo. You have 60 days from service to the end of that process. And 60 days comes and goes, and it's now after the statute of limitations has expired. The defendant who received the contractor said, heck, you blew it. You didn't actually file a lawsuit until after the 4-year period. And the property owner said, yeah, but I served the 558 notice and I've got to serve that before I can actually commence, i.e. file. And it went all the way up on appeal, and the appellate court said, we'll call 558 commencing a legal proceeding because of the way the statute is worded, and it's required as a condition before you can actually file the lawsuit. So an exception. Another exception is, and we'll come back to this later, counterclaim and cross-claim, right? So in legalese lingo, counterclaim and cross-claim are just different ways of asserting lawsuit claims against people who are either currently a party to a lawsuit or not yet a party. What does that mean? Well, you're a plaintiff, you're a property owner. You sue the general contractor, all right? General contractor is the sole defendant at that point. The general contractor can countersue the owner, right? That's a counterclaim. The general contractor can also bring in third-party defendants, so a subcontractor. That's a third-party claim. Once the subcontractor is also a defendant, the subcontractor can say, no, contractor, it's not my fault, it's your fault as a general contractor, and sues the general contractor. That is a cross claim. So cross claims and counterclaims do not have to be commenced, i.e. filed, within the statute of limitations. They can actually be filed after the statute of limitations has expired under a certain special rule. We'll get into that later. We said accrual is important. So you got to commence after accrual. What the heck is accrual, right? I mentioned it's the stopwatch, when the stopwatch begins. Generally, right, there's sort of two rules in a construction case for accrual. So you don't start counting until accrual. The general rule is that it's when the last element of the cause of action occurs, right? So a cause of action, say breach of contract, is a cause of action. The elements of breach of contract are there is a contract, it was materially breached, and one party suffered damages, right? So generally, in most causes of action, damages occur last, but there are circumstances where damages occur first, but the other elements don't occur until later. So you can't have a ripe claim and therefore cannot commence a legal action until all of the elements exist. For violation of building code, they have different essential elements, but all of them have to be present in order for an accrual to start, the stopwatch to start. Any questions on this before we move on to the next one?
Is 558 applicable only to private projects, or is it involved at all with the public sector as well?
There's really no answer to that question. The way 558 is set up, it has very broad definitions. In fact, we were talking about a road project just the other day, a paving project, and these are public rights of way. And it's unclear even whether 558 is only applicable to building structures, which was the original intent when it was drafted, but it doesn't define owner as a private owner or versus a public owner. Any other questions? All right. So the basics: construction defects against a contractor, means and methods, 4 years. That's the statute of limitations. That's the easy part. Design defects, we've got 2, right? So you have 4 years from accrual to commence an action. Design defects. Privity, 2 years, means the design professional, it has a written contract with the party that is suing the design professional, right? So that could be a contractor in a design build suing the design professional, or it could be a property owner as a contract with design professional. If there is a express written contract between the parties, it's 2 years. If there's no written contract, it's the same as the construction defect, 4 years. Now, I mentioned there are 2 accrual rules for construction defects. I'm not going to read the whole thing, but basically the special accrual rule for construction is 1, you got to have all the elements, right? So essentially damages have to exist, plus you have to have these other things. And this basically says, okay, it's the later of actual possession, issuance of the CO, occupancy, abandonment of construction, etc. So basically it sets out this, whichever is latest, that's when the stopwatch starts running. Any questions on this slide? Okay.
I got one question. How come when you hear statute of limitations, I thought it was 5 years, but I know the statute reads 4. What is the differential between 4 and 5?
Excellent question. So the 5-year statute of limitations is applicable to written contracts generally. So breach of any written contract. You have statute of limitations up to 20 years and as short as 1 year for different kinds of claims. Now, there are other claims that are commonly brought in defect cases to which a different statute of limitations may be applicable. For example, or a different accrual rule, or a different, we'll call it repose rule, even though it's not repose. For example, misrepresentation claims, or breach of fiduciary duty claims against a design professional, or Florida Deceptive and Unfair Trade Practices Act claims. So some of these unique ones all have different time periods. But the courts have interpreted in a case from some years ago that even though an owner and a contractor have a written contract between them, the 5-year rule, which is a more general rule applicable to all contracts, is trumped, if you will, by the more specific special rule for construction and design defects. And it is in fact a special statutory provision. It's in that 9511(3)(c) that's quoted at the very bottom. That is just a portion of that total statute. So there may be other types of non-defect issues that could be governed by a 5, a 2, a 1, or a 4 that has a different repose rule than we're going to be talking about. Any other questions?
9511(2)(b). Because from my understanding, whether there's any reference to the statute of 9511(2)(b anyway, a surety is on the hook for latent defects, whether it's written in a bond form or not, for the 5-year period. Is that so correct? Whether it's
yes.
in a bond form or not?
Because we're dealing with a written contract issue, and so that is true.
And and my understanding is no, a surety could not have any language in a bond that would eliminate that liability. In other words, you can't exclude a statute such as this from the surety's liability. Is that true or not true?
Contractually, you cannot modify a statute of limitations. That is true.
Okay.
In fact, there is the very next bullet on the slide is 9503, right? Specifically indicates that you cannot shorten a statute of limitation. In other words, you cannot say the 4 year is really 2 and you cannot opt into a different statute of limitations. That's the prerogative of the legislature to make the laws and the courts to apply them.
And would you say, because we do prime bonds and we do sub bonds, I guess a sub bond would automatically be applicable as well because the flow down provision that would be in a subcontract. So for all intents and purposes, a subcontract bond would in turn as well take on that 5-year statute of limitation period as well for latent defects?
It could, yes.
Good. And under a subcontract bond, could a surety eliminate or exclude or shorten?
I don't believe so, no.
Okay.
No.
So you guys got that? I understand. Regardless, a surety is on the hook for 5 years for statute of limitations as it relates to latent defects. Because a lot of our sureties really don't have a great handle on this stuff. Some of them handle multiple states, and every state has little uniqueness to their lien laws. So on occasion, we are having conversations about this.
Well, and they're tough technical issues, right? That these things have been sorted out and determined over a period of a decade and a half or more, right? Where by the time it gets through that slow trial court system that I mentioned, and it goes up on appeal, that's when the court has said, oh, by the way, for example, the design defects, privity, non-privity, that wasn't written in the statute because there's two statutes. There's a professional malpractice statute, which is 2 years, and then you've got the construction and design defect statute, which is 4. And it took years of going up through the trial court and appellate system for the courts to say, oh, well, when you harmonize those two things, the 2 year is privity, the 4 is no privity, right? It took years to get to the, well, construction defects is 4 years against the contractor, but you introduce a surety into the mix, that's a sort of a different kind of thing that falls under the more general 5 year. And even, these special accrual rules and the repose issues that we're going to talk about, it's taken years. So, 6 months from now, we have this discussion again, and I could give you a completely different answer because, the courts have changed their tune, or some new twist has come forward that has changed the law completely. So it's tough stuff. And particularly if you're not familiar with Florida, you're writing bonds in multiple states. Florida is very unfriendly to contractors and sureties, very unfriendly. All right, so we talked about you can't shorten it. How do you lengthen it? By the way, can't shorten it caveat. One theory we've been working on and we're starting to try to deploy is while you technically can't shorten the statute of limitations, trying to shorten the repose period is important, right? That can be shortened through legislative efforts, which those happen about every other year. There was an effort a couple of years back to get it down to 7, and then again a couple of years prior to that, it never makes it through. But repose, which we're going to get into it more in a minute, is all about sort of the, what did you know, or what should you have known through the exercise of reasonable diligence. And if you can contractually force a property owner, which you can contractually do just about anything, to make certain annual inspections, and there's sort of a process for that. If an owner fails to do that, it's entirely plausible the court will say, you didn't proceed with reasonable diligence. We're going to impute knowledge to you about this thing you discovered in year 6, and you're too late to file an action. So there may be some creative things on the horizon because it's getting very, very difficult for contractors, sureties, and insurers to continue in the current climate. So tolling is one of the ways that 4 years gets extended. Okay, so this is not statute of repose, the 10 years, which we're going to get to in a second. This is another mechanism in the law that is used to drag out the 4 year or 5 year or 2 year period. One of the ways is service process delays or problems, right? So corporations are supposed to have a registered agent. If they don't have a physical address, larger contractors, this isn't a problem. Some contractors don't specify an outside registered agent, or the service mechanisms of the statute can be difficult to obtain. You got to start with the president of the company, confirm they're not there, and then sort of go right on down the line if they don't have a registered agent. A registered agent isn't just the thing you file with the state in your annual SunBiz filing. That's where it goes, but to be a proper registered agent address, it actually has to be open during certain hours of the day. And so sometimes there are delays in service process that can allow for extension, basically to the extent of that delay. Bankruptcy. Okay, so there's no state law that says bankruptcy tolls in all circumstances. In the state statute of limitations, there's a provision that indicates bankruptcy tolls only if the bankruptcy is dealing with a tax certificate proceeding, right? However, bankruptcy law itself does provide for a tolling mechanism, and federal law trumps state law in this instance. And basically what bankruptcy law says is that you press the pause button. Effectively, that's what tolling is. Press the pause button on the stopwatch until either the end of the state statute of limitations, so the end of the 4 years or the end of the 5 years, and then you get that extra time, that pause time that the defendant was in bankruptcy, you get to tack that on. If the statute of limitation has not expired during the bankruptcy, But if it has expired during the bankruptcy, then you get 30 days after the bankruptcy is, the automatic stay of the bankruptcy case is terminated. Automatic stay goes into place the moment you file a bankruptcy petition, and it prohibits anyone from bringing a lawsuit against the debtor in bankruptcy. The automatic stay ends when the discharge injunction is issued, and that happens at the end of the case. There are other ways a stay can get lifted, but that's sort of beyond the purview of today. But the point is, bankruptcy can also provide tolling and extend that period. 558, talked about 558 before. Here's another area that appears. So as I mentioned, the 558 notice constitutes commencement of an action. So that effectively extends the repose period to 10 years. But you have to watch out. 558, you asked Warren, is it applicable to government projects? Well, here's an issue of inapplicability. It's inapplicable to incomplete projects. Don't ask me why, but that's what the statute says. If you have an incomplete structure, 558 is not applicable, and it doesn't act to toll. In fact, it's not applicable at all. So you don't send a 558 notice. There's no inspection mechanisms, opportunity to propose a cure, etc. Well, what's incomplete? Building that has no roof, incomplete. A building that's defective, the owner says you haven't finished the construction correctly, is that incomplete? That's fodder for argument, right? Especially those are the things you look at if the filing was just past the statute of limitations and the owner served a 558, you want to examine, could we argue that this building is incomplete and therefore 558 didn't hit the pause button and the statute of limitations was missed? Let's see, talked about that. Patent special rule. So patent defects, latent defects, we're going to get into this more later, but basically patent is open and obvious. Latent is the opposite of that. So with patent defects, you've got a shortened period. Basically, you've got 30 days after the end of the repair period is the special tolling for a 558 notice there. However, you should also note that parties can extend by agreement the 558 deadlines. And in fact, sometimes on large, complex projects where a 558 notice has been served, it's not feasible to complete inspections and make a resolution proposal within the statutorily allotted time. And if parties want to go through that in earnest, they will agree to extend those deadlines. Be careful, because that tolls the statute of limitations. That extends the statute of limitations. Condominiums also, right? So condominiums have a special rule. Turnover. So the statute of limitations is tolled until the developer turns over the condominium. Turnover is basically a term of art for when a duly elected majority of a disinterested board exists, right? So the developer is no longer in control, which makes sense because the board doesn't yet have the ability to bring an action until it's actually in control. So it's tolled during that period. However, the statute of repose is not tolled. So that 10-year period isn't tolled. So if the board is not elected until 4 years and 10 days, or in the case of a surety, 5 years and 10 days, that's okay from an owner's side, right? They still have the ability to commence an action. But if the board, for some reason, is not elected until 10 years and 1 day, that's tough on the ownership. They cannot bring an action because the statute of repose itself is not tolled. Other pre-suit dispute resolution mechanisms also are not tolled. So, for example, in the AIA contract documents, you have the initial decision maker, typically the architect, unless that's been modified. You might have mediation as a condition precedent to arbitration or litigation or non-binding arbitration as a condition preceding, those things do not toll the statute of limitations at all. So you want to be on the lookout for that. Any questions about tolling?
I've got a question. What if in a contract, it references latent defects being applicable, either by words or by statute? Does that automatically mean that the surety bond is on the hook for it when there's no reference in the surety bond? Say you're using just an AIA A312 bond form. The reference to that in the contract, does that automatically put the surety on the hook?
What would the reference be? What's the context?
Latent defects. That the contractor is responsible for latent defects, either in those simple words or specifically referencing 9511(3)(c).
So contractors are responsible for latent defects no matter what, provided the action is timely commenced, right? And so if the question is, can a sort of sweeping reference to latent defects extend the deadline to commence an action, the answer to that is no. I'm not sure if that's your question.
No, I guess does it automatically mean that the surety is on the hook for it under their performance bond? Because there's a reference to it, the contractor being on the hook. I know you, like you just said, contractors on the hook for it regardless, or is the surety only on the hook for the 5 years? And that's it.
Well, you can still have, that's a good, okay, gotcha. So the statute of repose, the 10 years, is only applicable to the 4-year statute of limitations. All right, so to the extent the action against the surety is governed by the 5-year, there is no statute of repose. Let me state that differently. The law in Florida generally is this: a party who wants to sue has a deadline, the statute of limitations. That deadline exists whether the party knew about the claim or not, right? So if you snoozed, you slept on your rights, or you just didn't even know there was a problem, that's tough. However, there are exceptions. The 4-year statute of limitation for construction and design defects against a contractor or design professional has a built-in statute of repose. That's the 10-year period that we're talking about. That 10 years is only applicable to an action of that nature. Fraud claims, as an example, have a repose-like concept. It's called the discovery doctrine, and it uses similar language. That actually doesn't have a 10-year cutoff. It's just from when you knew or should have known about the fraud. There is applicable to the action against the surety, all these tolling concepts that I mentioned. These are not unique to actions against contractors and design professionals. All of them are applicable to likely the surety bond. Also, there's a concept in the law that I haven't covered here just because of time, called equitable tolling. That can be applicable to all types of claims. Again, it's not a repose, but it can extend the statute of limitations of 5 years to something longer. Essentially, if, to boil it down, if the defendant, the surety, and this is very unlikely for a surety, if the surety had possession of information that it intentionally held and concealed, and that it engaged in misrepresentations and lied to the project owner to induce it not to bring an action. Do contractors do that? Sure. That's more likely an issue with a contractor, an action against a contractor, less likely with a surety, but equitable tolling is still in the mix. Does that answer your question?
Yeah,
Okay.
but I got to piggyback on that one.
Okay.
If in the performance bond, it references that the surety is on the hook for latent defects under 9511(3)(c). Is that therefore a form of tolling the statute of limitations by having it in the bond form? Or is that verbiage in there really worthless because a surety cannot be extended for the statute of repose, that they're limited under contract to the statute of limitations?
I don't know. I don't know that there's a case that's decided that issue. If there has, I haven't come across it, but I'll make a note and circle back with you on that. Are you seeing more owners requiring language to that effect in a bond?
You know, I've had varying dialogues with different sureties over the years. I've had sureties say, if it's in the bond form, then we're accepting that and we are on the hook for it, for the statute of repose. And then I've had those, a lot fewer of those that say, and I think I even had an attorney telling me as well, that the surety can't be on the hook for anything more than 5 years, and they're on the hook for that regardless. So having the 9511(3)(c) in the bond form really doesn't mean anything. So that's, you know, kind of what prompted the fogginess as it relates to the issue, and that's why I wanted to ask you if you've seen that.
Yeah, sort of in a roundabout way, I sort of answered that because while I'm not walking around the lawyer's brain that gave his answer or her answer, I agree with the answer and concept from the body of law that I do know, which is that you can't alter the statute of limitations by contract. Generally, you can't pick the one that's applicable. And so basically the parties are trying to say by contract or stipulation, we want the ability to sue you for a longer period. And I am unaware of a case that allows the parties to do that. But I'm going to do some additional research on that and circle back with you. I think that, like I said, maybe there is no such case and it's a creative mechanism to extend. And at some point, I'm sure the courts will get to ruling on that if it goes that far. But that's an interesting question.
Okay.
Anything else before we move to the next slide? Repose. All right, repose. So I'm definitely not going to read all of this, but basically, remember I indicated that repose is the thing that extends that 4-year period or for design professional actions or construction defect actions, right? And the key language really is that it runs, right? That's accrual. Runs means accrual, start to stopwatch, from when the suing party should have discovered, actually discovered or should have discovered with the exercise of due diligence. All of the cases address the should have been discovered, right? Nobody's fool enough generally to take an appeal over, I discovered it, I knew it, and I filed late. So all the published decisions really deal with the rest. But as with everything, there are exceptions to the rule. By the way, the 10 years follows the accrual. Remember I said there were 2 accrual rules, special rules for construction. One was the last element of the cause of action. And then the second was issuance of the CO, abandonment, actual possession, termination of the contract, et cetera. Well, that same language exists here. So it's 10 years from the later of those various things. But as I mentioned, as with everything, there are exceptions to this tense. In other words, you got the tolling that can extend things. You have the 558 that can extend things. And there's something else. And that is that same example I mentioned with cross claims, counter claims, but here it's a third party complaint. So it's the example of a contractor has been sued. Let's say it was a latent defect, right? That was discovered and late, and suit was timely commenced within the 10 years by the owner against the general contractor. General contractor gets served with a lawsuit and says, this isn't my fault. This is the plumbing subcontractor's fault, and wants to add the subcontractor as a third-party defendant. General contractor has 1 year to do that after the general contractor was served. So essentially 11 years. So that's one of the big exceptions to the 10-year hard limit. Questions on repose generally, we're going to get into this, latent patent stuff next. All right, on to latent patent. So I mentioned patent basically, right? Obvious that there is a problem. It's not limited to that, however. Courts have said, so you can't go through with blinders and say, oh, no, I don't see it, I don't know it, right? Court can imply knowledge. That is a possibility, but it's highly fact dependent. So it really depends on the knowledge, generally the experience of the party bringing the action, generally the owner, and what they should have known under the circumstances. So sort of the classic example of patent defects are roof leaks. And the very first such roof leak case was a school board case in Seminole County. Basically, school board discovered that there was mold, there was high levels of humidity, there were trails of water on the walls, but waited until after the statute of limitations expired to bring an action. Essentially, it later got inspections done after the 4-year period and said, oh, it's most definitely the roof. Didn't determine that officially until after the 4 years, brought an action, said statute of repose, we're well within the 10, we should be good. Trial court disagreed, it went up on appeal. Appellate court decided with the roofing contractor and said, look, right, it's pretty darn obvious that when you got mold on the walls, high humidity levels, sort of trails of moisture coming down the walls, and you had roofing done recently and didn't have the problem before that, it's pretty obvious there's a problem with the roof. Now, you don't know exactly what the problem is, right? You don't know if it's an underlayment issue, if there's, rotting in the decking. You don't know exactly what it is, but you know that there's a problem. And so we're going to imply knowledge. All right, so what is latent? As I said, latent is sort of the opposite of patent. The manifestation is the term that the courts use. The manifestation of the defect is not obvious. Other cases, right? These are all very fact specific. So in this particular case where I said, defects observable solely by the owner or solely by an expert, the owner claims it didn't realize that there was a defect, but had periodic inspections done by, we'll call it a construction consultant or someone who was more appropriately trained, not a forensic expert, but a consultant essentially. And the consultant, this was after the 4-year period, the consultant renders a report that says, okay, you've got these defects. The owner rushes to file suit well within the 10-year period, so well within the statute of repose. The contractor says, well, wait a minute, you should have discovered this stuff within the 4-year period, right? Exercise reasonable diligence and all of that. And as proof of that, the contractor argued, your consultant pretty easily discovered it right after the 4-year period. I mean, it wasn't even like a major hidden thing where you had to tear wall cavities apart or anything like that. It was sort of obvious. You just didn't observe it. That's your problem, owner. And the court said, nah, we're not going to go that far, because if the defect isn't manifesting, right, if it's not truly observable to the untrained eye, the untrained construction eye, then we're not gonna tag the owner for that. The fact that someone who had better training did quite easily see it and didn't have to tear walls apart and things like that, or demo a slab, we're not going to imply knowledge to the owner. Again, so it gets very specific of who are we dealing with before the court's going to determine whether that party should have known through the exercise of reasonable diligence. And what is reasonable diligence? Does reasonable diligence mean you have to have your building inspected every year? Not necessarily, but wait, remember earlier I alluded to this idea that in a contract, you could impose an obligation on a property owner to perform annual inspections or maintenance obligations, things of that nature. Well, if you've got a contract standard that specifies the reasonable diligence that the owner has to take after construction is complete, you may have effectively contractually altered the statute of repose because you are creating an obligation of reasonable diligence, and then the owner has to hire an expert if it needs to perform those inspections. So that's one creative way. I haven't seen it before other than things that we're doing. I don't know what the law will say about it. But again, with these cases being very fact specific and the courts looking at contract terms and what the parties were doing and what they knew, I think that's got a pretty good shot. It's worth a try. But wait, as with everything in the law, there's unpredictability and exceptions, right? So there are just as many cases out there that say, oh wait, the obvious roof leak, that's patent, clearly patent. There are roof leak cases where the court said, that's not patent, it's latent. So again, it's highly, highly fact specific stuff. There is the takeaway with patent versus latent is there's no bright line rule, right? There's no if this, then that is the outcome. And that's the tough part about the litigation process, right? Is to the contractor who's defending or the surety says, hey, look, this stuff is clearly patent, your time order. The court rules, the rules of civil procedure allow for discovery to develop before you can even try to prematurely end a case through summary judgment before trial where there's no disputed issue of material fact. And so that can take years and lots of dough, which is one reason why arbitration can be a much better alternative, especially with the backlog. And you can select arbitrators or specify them rather, arbitrators that have actual construction experience, and you can shrink down the dispute resolution time and customize your own rules. Of course, that has to be done contractually in advance, unless the parties agree to arbitrate after a dispute arises. But it's a big issue because, again, discovery is sort of one of the biggest and most expensive parts of a case. And if your approach to settlement hinges on whether something's patent or latent, you're not going to know that probably until trial, sadly, if you're in the court system. Questions about patent versus latent?
Nope.
Warren, your guys are easy.
I think they're sleeping. Wake up.
Uh-oh, I'm not doing, I know it's.
Now you're this not the most interesting, but you're doing a great job.
Yeah, it's
a tough topic. They're tough topics.
It is. Well,
They're
there's
complex.
other topics that are certainly more enjoyable. And this stuff, it's just highly technical stuff that there's just not a really fun way to present it. But
right. No, you're doing
You're doing
phenomenal.
Yeah, you're doing good.
well, I'll tell you what, I know you wanted to keep it to around 45. We're a bit past that. Are there any, this was sort of the end of the repose discussion. Are there any other questions that anybody has on any topic before we sort of bring it home?
I have a question that seems to be coming up over and over again, and I'd love some clarification from you on it. When we have a contract and we have bond forms where there is contradiction between the two, a lot of times we have to change a bond form when there's a contract that's already been executed. And obviously we cannot get our client to turn around and get the owner or the GC to change the terms of the contract. So we try to protect the client and the surety via the bond forms. When it comes down to it, what is your stance on contract versus bond forms when that issue arises, if God forbid it gets to a court of law?
I think the short answer is it depends on the nature of the conflict, right? Because you have the general body of suretyship law that says the surety has the same defenses as the contractor, right? So you step into the shoes of the contractor. Well, the contractor doesn't have the same defenses as the surety. So if you're looking on the surety side, you look at it and say, okay, well, what defenses does the contractor have? Contractor doesn't have the defenses that you want it to have because the construction contract itself does not contain those concepts, whatever they are. So you can't, if you will, impute it. So then you're looking just to the bond and say, okay, well, the bond has some unique concepts, right? And there is general law that says not only does the surety have the same defenses as the contractor, but sureties have their own defenses that are unique to suretyship law, right? For example, there's been a significant change to the scope of the contract, and the surety was unaware and never approved that change.
In reality.
Well, let me give you the examples that we see. We see, let's say, for example, warranty difference between bond form and contract, or consequential damages that we strike from the bond form and are still in the contract. Those would be probably, I don't know how the other guys feel, but two of the issues that we see that a surety comes back and wants changes to.
Gotcha.
Yeah, like you said, it says in the contract that contractor's on the hook for consequential damages. And then it's in the bond form as well, but we cross it out. Does that mean the surety's not on the hook for consequential damages?
That's a great question that I don't think there's an immediate answer to. I mean, I have my opinion on it, which is I think that my argument would be the answer is no, the surety would not be liable for consequential damages if it's stricken out of the bond form, because
bond form.
damages is a different and unique type of damage. It's not, in other words, you've got different kinds of damages. You've got compensatory damages, which are essentially actual traditional damages. You have consequential damages like loss of revenue from the operating hotel because, the rooms weren't all ready. I mean, that's typically liquidated damages in those types of contracts, but consequential could be additional loan carry costs of the project owner. I don't think those were ever the kinds of damages that suretyship law contemplated would be covered by a performance bond. So my argument would be no, the surety would not be responsible for those, notwithstanding that the contract between the contractor and the owner does contain those things. But I don't know that there is a solid answer to that question through the courts.
And I know what we've tried to do is, instead of eliminating consequential damages, where obviously someone would have to read through it to see that it no longer exists, as Warren said, we strike through it so they could see it has been intentionally stricken through. And if they accept it, versus trying to sneakily erase it from the form. You know what I mean?
Yeah, the in your face, hey, you can't claim you didn't know.
Right.
You saw the red ink.
Correct.
So if there was no reference to consequentials in the bond form, then it exposes the surety. In other words, are you less certain, or are you more iffy as to whether a surety can be brought in for consequential?
I think you lose one of your arguments if it doesn't contain the reference at all. But and I don't think it's not an issue that's well settled in Florida. So much of construction law and particularly suretyship law comes from outside of this state anyway. The courts just haven't grappled with that concept enough to have a clear answer to it.
And I know on warranties, what we're infamous for doing is writing in the bond form that the surety is only on the hook for basically 1 year versus the 5 years that the contractor is on the hook for in the contract.
Mm-hmm.
So I guess it's the same type of scenario. By stating it there and them accepting it or not disputing it, that's sort of going to be the surety stance.
I think it's a good position to take, yes.
Okay. Thank you.
Sure.
Anybody else have anything?
No, that was my question.
Justin, greatly appreciate your time here.
Yes, thank you so much.
You bet.
Very informative.
If you invite me back, I'll try to present something with some better stories. There aren't many fun stories about statute of limitations and repose. So I was sitting here creating this in the slides, and I'm like, man, because I'm big on telling funny stories. You know, good stories. It's just like,
There's nothing
Tough
funny about this
sliding.
stuff.
Well, I think if you can get that wheel in the background to turn, it'd be more fun. But no, I really appreciate it. And you said you will be providing us with a recording, correct?
I'll provide you with the recording, and I'll
Awesome.
send you over a PDF of the slides as well. And I will circle back with you on the latent defect extension, but I'm darn certain that that there is no case on that issue, but I feel very strongly that you cannot apply that 10-year repose and that other statute of limitations just by referencing a statute. Otherwise, I'd reference all kinds of statutes. I'd make it, make it a crime to do X, Y, or Z, even if it wasn't. It's just not, the law just generally doesn't allow for those things, especially for things like statute of limitations and repose.
Perfect. That's good news for us.
Well, thanks a lot for your.
Thank you so much.
Thank you. Thank you so much for taking the
Justin.
time.
Yeah.
You bet.
Have a great rest of the week.
You too.
Thanks.
Bye-bye.